Gentlemen of the jury, welcome back. First and foremost, I do apologize. It took a little longer than I expected. I take full responsibility for that. Do not hold that against the parties at all. You will see after the instructions and after the closings, and I give the instructions that they are lengthy, and that's what took a while to. I needed to make sure that they were all appropriate and correct. So we are though now at the stage of closing argument, and I have one very brief instruction before the closing arguments. The parties now will present their final arguments. Please remember that what the parties say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has given his closing argument. State ready to proceed?
Yes, Your Honor.
All right, Ms. O'Connor, you may proceed.
May it please the court, Mr. Summers, co-counsel, gentlemen of the jury, a nightmare that Elisa Mathewson has had to relive for 5 years now. To relive in front of you, testifying here during this trial. Relive the traumatic events that she was forced to endure by that man, the defendant. What this comes down to is a scorned lover. The defendant was not willing to come to grips with his divorce with his ex-wife. If he couldn't have her, then no one could. And that is what leads us to what happened March 11th through March 13th of 2017. The judge is going to instruct you, and you will get a copy of these in regards to the charges. In order for the state to prove the crime of attempted murder in the first degree premeditated, the state has to prove to you these 3 elements. Trevor Stephen Summers did some act intended to cause the death of Elisa Summers that went beyond just thinking or talking about it. Number 2, Trevor Stephen Summers acted with a premeditated design to kill. And then number 3, the act would have resulted in the death except someone prevented him from killing her or he failed to do so. You're also going to receive an instruction for aggravation of the attempted first-degree murder with the use of a weapon. The facts are clear. You heard from Ms. Mathewson after the second act of sexual battery against her by the defendant, he makes her shower. He then has her get back onto the bed. He leaves the room. He's gone for some time. She can't say how much time, but he's gone for some amount of time. And then he comes back in and, quoting Miss Mathewson, "All I saw was an expression of evil and hatred. And at that time, I thought he's here to kill me. I'm going to die." And as she sees that look on his face, she notices he has something he is hiding behind his back. He then comes over to her as she is on the bed, tied up, and puts the pillow over her face. She starts struggling. So what does he do? He then gets on top of her, straddling her, applying more pressure to that pillow, to the point where she is thinking to herself, she knew where she was going. She was going to meet Jesus. And then she loses consciousness. And we know he did this because he admitted to that to Sergeant Remia in his post-Miranda statement. And we know that he stopped and took the pillow off of her. Otherwise, we would be here for a different case. There was no heat of passion. One of the additional instructions as far as the attempted murder is that you will see that it is not a heat of passion. This is not a heat of passion. He knew exactly what he was going to do when he went into her room while she was tied to the bed. Keep in mind, this was hours after he had snuck into her house, shortly after 12:30 that morning. Hours after he had lingered in her home for several hours before waking her up in the middle of the night. After numerous times where he ties her up with rope, Christmas tree lights, a vacuum cord, there was no heat of passion. As to count 2, for the attempted murder, this was from March 13th, where they get to Little Harbor. He parks by a dumpster near the Hooks restaurant. We heard testimony from Ms. Mathewson that he is in the driver's seat. The defendant says that he needs to write a letter to his parents. So what does he do? He climbs into the 3rd row, gets directly behind her, who's in the 2nd row, and keep in mind, at this time, she's tied up. She showed you. She's tied up with the rope around her body with her hands up in a clenched fist-like fashion up around her chin. If he really needed to write a letter to his parents, why go to the 3rd row? Submit to you. We all know that that's not why he was going to the 3rd row. He had already written all the letters. You had heard testimony from Ms. Mathewson that happened well before they were at Little Harbor. He went to that 3rd row with the intent of pulling that rope and strangling her. State's Exhibit F5. We see the rope that was tied around Miss Mathewson's arm, that was used to tie around her body, and the rope that was then used to strangle her. Looking at State's Exhibit F6, this is a close-up of the rope tied to her arm. And then if you go back and look at the photographs that were taken by crime scene at her house, Miss Mathewson's house, the rope that was found in the trash can, and this is in State's Exhibit Set 1, A38, we see the black rope in the trash can. The exact same rope. The rope that you heard Miss Mathewson say she saw him pull from his pants pockets the early morning of March 11th of 2017. He went to her house with this rope. Why would you go to your ex-wife's house with rope if all you're doing is intending to talk? State's Exhibit K3 shows you the linear line on Miss Mathewson's neck, on the left side of her neck, and K4 showing how that line goes around to the back side of her neck. And those are the photographs and observations that Ms. Hall, an advanced registered nurse practitioner who conducted the sexual assault exam, as you heard testify, observed on Ms. Mathewson. And you heard Ms. Hall say that these types of marks can take up to 24 hours to appear. So while you may see it on the left side at the time in which she did the exam, it's possible that there could still be some marks appearing on the right side of Miss Mathewson's neck based on the strangulation with the rope. You also heard the testimony from Ms. Hall that the linear line is consistent with that coming from a rope. And then what else did she say? That it had to have been applied with enough pressure to leave that mark. Again, this was no heat of passion. This was premeditated. He had no intention of them leaving that vehicle at Little Harbor. By the grace of God, what he thought to be an undercover vehicle drove by, and he got scared. He failed to follow through with what he intended to do for a second time. As to count 3, we have the kidnapping incident from the Walgreens. Go back, listen to that 911 call from Mr. Crosby, Exhibit C. Consistent with what he testified to here the other day. We heard testimony that once they get to the Walgreens, the defendant parks the car away from the store. He goes into the store. Remember, her hands are tied behind her back. And she still had that blanket over her shoulders that he put on before leaving the house. She's somehow able to move her arms a certain way to unbuckle herself and then open the door and get out and try and run. And she told you she ran to the main road because she knew she couldn't go in the store. That's where he was at. Hopefully thinking that somebody driving would help her. Unfortunately, the defendant saw her running out of the car and she wasn't fast enough. You heard Miss Mathewson testify that he grabbed her, picked her up, forced her back into the passenger seat as she is struggling and fighting to keep him from putting her back in there because she knew she knew what was going to happen if he was able to get her back in that car. And then he drives off. And you heard her testimony that she was able to get the door open one more time as they're driving. He stops the car, then buckles her up, ties her, and slits her wrist, saying that's for trying to run away. The defendant admitted to Sergeant Remia that she ran. He went out after her, grabbed her, put her back in the car. He even admitted that her hands were still tied behind her back. And then he tied her to the seat. He goes on to describe how from there, because now most likely the authorities are going to be contacted, that there's no way they're going to be able to go to his house and say goodbye to the children. So he drives for several days through Manatee County and Hillsborough County. In the kidnapping instruction, you will see for element number 3, the state has to prove the act was committed with the intent to commit or facilitate the commission of a grand theft of a motor vehicle. And that is in count number 10 as a separate charge. And the state submits to you that the grand theft motor vehicle started when they left the house before going to the Walgreens. Because we know her hands are tied behind her back. We know she's not the one driving her vehicle. We know the defendant is the one who took the keys, puts her in the back seat, and drives. We also know from his own statements, again, that he is the one who drove throughout Hillsborough County and Manatee County for the next few days, throughout the 11th, the 12th, and the 13th. At no point in time did Ms. Mathewson ever drive her own vehicle during those 2.5 days. One of the elements as far as the grand theft motor vehicle that you will see is that the defendant knowingly and unlawfully obtained or used or endeavored to obtain or use the motor vehicle. Well, we know he was using it. He didn't have permission to do so. And temporarily or permanently deprive. 2.5 days where she doesn't have access to her own vehicle. Several times throughout, she is tied either to the car, the captain's chair in the car, or tied herself. The state submits to you that the kidnapping facilitated the theft of her motor vehicle. Now, as to counts 4 and 5, the sexual battery, the state's required to prove to you 4 elements. And I submit that elements numbers 1, 3, and 4, those are not at issue here. We know that the defendant, per his own statement, had sex, according to him, with Miss Mathewson, and that his penis penetrated her vagina. We know that they're both over 18. The issue is element number 2, consent. So let's look at the definition of consent. It means intelligent, knowing, and voluntary consent, and does not include coerced submission. Consent does not mean the failure by the alleged victim to offer physical resistance to the offender. The state does not have to prove to you she tried to fight him off. The state does not have to prove to you that she said no. You broke into my home in the middle of the night when I was sleeping, attacked me, and tied me up. I call that rape. Miss Mathewson's words just the other day. That's exactly what it was. She felt that she had no other option. And I want you all to go back and pay close attention to the defendant's post-Miranda interview, because every other time the defendant talks about having sex, he describes it as sex. We had sex. We had sex. Pay close attention around the 15-minute mark when he describes the sex that occurred on March 11th of 2017. He says, and then we had sex 4 times, consensual. It wasn't forced, nothing, completely consensual. The one and only time that he described it as being consensual. Why is that? Counts 6 through 9 is the child neglect of the children. And I'm not going to put up all of the instructions because they are all the same. It'll just have the different initials for the children. But the state is required to prove to you 3 elements. That the defendant willfully or by culpable negligence failed or omitted to provide the child, in this case this is going to be for Arden Summers, with the care, supervision, and services necessary to maintain Arden Summers' physical or mental health. He was a caregiver, and then at the time, Arden was under the age of 18. There's no disputing this at all. We know for a fact he let his 14-year-old daughter drive home, about a 26-minute drive, from Miss Mathewson's house to his house around 6 o'clock in the morning. You heard from Arden Summers, she didn't even know where she was going. Luckily, she knew how to use the navigation system in the van. And then, once all the kids are home, there's no adult. You have Arden and her other siblings, Bryn, Grady, Landon, and Cooper, all home until about 3 a.m. on March 12th, when law enforcement knocks on the door of Carol and Stephen Summers, asking one of them to go over to the house because there's no adult. And prior to even Arden arriving back at the house with her siblings, we know that the defendant had left the youngest child, Cooper, who was 3, at home, all alone. because he was asleep. As to count 11, we have the violation of the DV injunction, the domestic violence injunction. Again, there is nothing in dispute with this count. The interview the defendant provided to Sergeant Remia, the video that the defendant made on Miss Matthewson's phone is Exhibit Y. And we have the order of the injunction in service on him, which was Exhibit AA. So, the evidence that you received in this trial is overwhelming. But all of it, the 911 call that was made by Mr. Crosby, the Walgreens video, the text messages that were between Arden, Landon, and the defendant, the videos the defendant made, the confession letter he wrote, the letter he wrote to his kids, states Exhibit S3. Where he says, "We wish you the best in everything you do, and we'll be watching you from heaven." His own statements to Sergeant Remia. The testimony from Deputy Cruz of Miss Matthewson when he was able to extract her from that vehicle, the sense of relief on her face, how frantic she was, how upset she was. Of course, the ordeal that she had went through, and the relief was because she knew if nobody had found her, she would be dead. I want to talk a little bit more about the defendant's post-Miranda statement to Sergeant Remia, as there are additional statements he made other than what I have already discussed with you. Contradictory to what the defendant claimed, this is not a situation where you have two individuals who are quarreling over a divorce. His comments to Sergeant Remia about how it messed up his mind, she was messing with his head, is nothing more than, again, him not wanting to accept the fact that their marriage was over. There were no mental issues or health issues that the defendant was having. This is not an insanity case. You will not get an instruction on that. And that is not something that you should consider. There is nothing wrong with him mentally. He just could not get over the fact that she began dating. And according to him, was lying about it. And that's what made him upset. Gentlemen of the jury, shortly after 12 a.m. on March 11th, 2017, when the defendant snuck into Miss Matthewson's house in a window on the side of the house, not through the front, on the side, he did not have the intention of just talking. You don't sneak into somebody's house in the middle of the night with the intention of just talking. I submit to you, he also never had any intention of either of them getting on a boat and going to the islands. His intentions were for her, at first, never to leave that house. And then when that didn't work out, to never leave that car at Little Harbor. The state has presented to you an abundant amount of evidence that proves beyond a reasonable doubt the charges in which he has been charged with.
Mr. Summers?
Thank you, Your Honor. Good afternoon, gentlemen. Good afternoon, Your Honor. Good morning, Your Honor. Good morning, gentlemen. Good morning, State. I'd like to just be able to share with you a re-representation of what we've heard over the last week. And I'd like to start with just helping you understand from the details that were given and consider that the condition of both myself and Mrs. Mathewson were not adequate enough to truly paint a picture that you could understand. If you recall, we spent a lot of time that weekend just talking, just trying to figure things out, wrestling around, fighting about a variety of issues. Some of them you heard about, some of them you haven't. But you do remember that we didn't sleep very much. Our emotions were all over the place. Our stress was high. You've heard these things through her testimony and through statements of others in this case. And so I ask you to please keep that in mind as you look through, as I walk you through the facts that were presented. I first ask you to pay attention to the photographs. As you walk through the photographs, I ask you to please look through them and notice things in the residence of Mrs. Mathewson. That there were no signs of a struggle. That there was not broken glass or dents in walls. There's not scratches on countertops or blood splatter. This was not a scene that depicted some kind of crime or some kind of anything more than what she described as wrestling around. And I also ask you to look and see that the things aren't thrown about as she described. Things are where they're supposed to be. You can see that we packed, we left, and we had a plan to go to my house. Her accusation is that she was tied to go to my house. But I ask you, does it make sense to go meet children with a woman tied up? I also ask you to look at the items that were disturbed by law enforcement during their 3 times investigating that home. There are a number of things, statements that were made, including a variety of articles within the home that weren't brought in front of you, so that you can't make conclusions, so that you can't corroborate the stories or the statements that were made here. I also ask you to look through the pictures of the vehicle. I ask you to consider that they don't line up with her stories either. Little things like the pancake platter sitting in the second row and not the third. Little things like a purse being full of all kinds of contents that were helpful to her, useful to her, that she didn't really need if the whole intent to take her somewhere and kidnap her or steal her car. Why would she need her purse? Why would she need her phone? Why would she need her charger? It doesn't make any sense. And I also ask you to look at the car handle. The car handle's far up in the front of the door. And her statement is her hands are tied behind her back. I think most of us understand that if you lean your back against the car door and you pull the handle, you're going to fall out, you're going to tumble on your head. But she didn't say that happened. I also ask you to look at the pictures of Mrs. Mathewson. You'll see the full pictures when she was evaluated and examined after these events. You'll see that the bruises line up with wrestling around. You'll also see marks, bruises on her arms where she said, I lifted her up through a ravine. And you'll see exactly that's true. We pulled her up through a ravine. You'll see that there are blisters on her heels. Again, I mentioned to you guys, or I questioned her about why she didn't put flip-flops on, why she would put shoes back on if she already had marks on her heels. And her answer was non-responsive. And so,
Objection, Judge. Inappropriate misstatement of the facts.
Hold on. Well, I'll instruct the jury at this time that what Mr. Summers says during closing and the attorneys during their closing is not evidence in the case. I will instruct you to rely on your own recollection of what the testimony and evidence was.
gentlemen, if you remember, we walked through those fields for hours in muddy conditions. Those shoes, as Ms. Mathewson testified, were getting stuck in the mud, and clearly that's what caused the blisters on her heels. You won't see any kind of rope burns on her wrists or her ankles. They're not there. You also won't find any photographs of anything after that. The law enforcement failed to investigate anything further beyond Ms. Mathewson's condition to see if another bruise would show up on the other side of her neck, or if any bruises or marks would show up anywhere else. That would have probably been a normal thing to do. And you'll also see that we physically fought each other. I don't argue that with you. And I also ask you to look at the photos of Mr. Summers, of myself. You'll see that I was in no condition to be interviewed by the police. You'll also see that if you were in that position, you would feel vulnerable. You'd feel taken advantage of. You see that I was restricted, I was captive, and possibly coerced. And I argue that. Aside from the pictures, gentlemen, I ask you to look at the videos. If you look at me at Ms. Summers' house, I'm in a confused state of mind. We're going through a divorce. We don't know what's going on. I questioned Ms. Mathewson about our conversations about her pregnancy, and she recalled some things that we had talked about. This was something that I want you to consider. I also want you to consider a very special moment in that video where I'm asking Ms. Mathewson what else she would like me to say. I submit to you guys that when you're in these kind of positions, you can clearly see through the complexity of this evidence and through the variety of it, how the emotions are all over the place. I also ask you to look at the Walgreens videos. Mrs. Summers goes into, or Mr. Summers, myself, and I go into the store, but that's the opposite of the state's witness. He doesn't see me go into the store. He doesn't even know where I came from. That's his testimony to you guys. He doesn't know what kind of clothes I'm wearing. He doesn't know what kind of clothes she's wearing. But this is the main witness that's supposed to identify that the one single thing that he saw was her hands behind her back. He said her hands were behind her back, and I don't know how she ran out of the car. But were they tied? You have to make this decision. Again, I point to you, how do you get out of a car with your hands tied behind your back and open a door and not fall out? I also ask you to look at that Walgreens video and see that it was parked right in front of the store. If someone's held captive in the car, I don't think it's logical that you would park right in front of the store. I think you would park somewhere where no one else might see yet. I think you would probably park in a different way so that if you needed to, you could get out quickly. But the testimony was that the vehicle was pulled directly in front of the store, head first into the parking spot. I also ask you to consider looking at the vehicle not speeding away. There was no rush to leave there. It wasn't that much of a concern. It was a moment of panic. As you also look at the other videos, please look at the McDonald's video. Mrs. Mathewson was free to leave. It was a perfect opportunity. If this is true, if all this weekend, after 50 hours, all of these things were true, what better opportunity than there for her to leave? She had the opportunity to order what she wanted. She was not being held by myself at all. Now, I know the video played with a little bit of choppiness earlier. I'd ask you to watch it again and see if you can get it to play smoothly and see that, no, this is a agreed upon situation. We're in there together, we're getting breakfast, we're moving on. I also see that she is cooperative with me. She's using her purse, she has the contents of that purse, and there's no issue that whole time, almost 2 minutes, maybe even more, of going through that drive-through. Logically, I would not be able to get out of that vehicle. I had a seatbelt on, and my door would immediately hit a building. And again, a great opportunity for her to leave. As you look at the Citgo video, there are 3 videos on there. 2 of them show me inside the store. One is from a different angle where you can see that the vehicle is not parked at the first pump. I ask you to look at that. Ms. Mathewson states that I pulled as close to the store as possible and right next to the first pump. That's not true. I didn't have any concern about where I had to pull, close in proximity to the store. You can see that from her vehicle where her gas tank is and where you have to pull into the gas station. It's just logic sense. You can also see that I was there inside the store for a number of minutes, and then again, another opportunity for her to just walk away, run away. I remind you guys that this is 6:50 in the morning on a Monday morning. There's people all over the place. It's rush hour.
Objection, Judge. Facts not in evidence.
I will instruct the jury, again, that anything that Mr. Summers or the attorneys for the state say is not evidence, to rely on your own recollection as to what the evidence was in this case and testimony that came from the witness stand. I will instruct you, Mr. Summers, to avoid arguing things at this time that are not in evidence.
Okay. Gentlemen, just remind you that they showed the time on the receipt of the McDonald's slip, and that it was a Monday, and it was just before 7 a.m. Also, then ask you to consider the testimonies of the people given. The first is Randall Crosby. Again, he does not recall where I came from. He does not recall what clothes I was wearing, what clothes she was wearing. His statement is pretty inaccurate. He doesn't recall what vehicle it was that was 15 feet from him, even though the name and the insignia is right on the back of it. Only he was focused on was getting that license plate. He was paying attention to that, not what was happening with us. I don't understand how he could be able to look at the vehicle and get the license plate at the same time pay attention to what we're doing. He was also on the opposite side of the vehicle in orientation. He's standing by a red box machine. As you look through the videos, as you look at the overall of that store, you'll see that his position was not a very good view of our position, of Mrs. Mathewson running away, of my position coming out after her. He did not chase us. He did not follow us. He was also the only person standing outside at that time. You'll see a few other people walk into the store a little bit later. All of these people were also available to Ms. Mathewson to go and talk to. If I'm in the store, she could have went and talked to him or tried to seek help from him. He also, in his 911 call, you can listen to that, it says that he didn't even know the street location of where he was working. He didn't know that the place of his employment in his testimony, or what time he started the shift, what time he ended. He was also not close enough to hear the things that were being yelled at each other. Mrs. Mathewson said that she yelled. We were screaming at each other as we were going back to the car. But he couldn't hear that. I then point to you to Kimberly Shea, who gave you a very accurate evaluation of what she saw. Her statement was true. She was pulled in directly across from the passenger side of that vehicle. She saw the emotion on Mrs. Mathewson's face. She saw that we were in some kind of an argument, some kind of a torment. And she also saw Mrs. Mathewson's hand. She saw her hand leaning on the door sill and leaning up against her face. That wouldn't indicate that her hands were tied at all. I also point you to Ms. Shea's knowledge of the exact type of vehicle it was from the moment that she saw it, color, the position, how far she was exactly from the vehicle, and that we left. Then we go to David Chesla, Dr. Chesla. Dr. Chesla did not operate on me as he stated. He also doesn't remember even seeing me. He could not tell exactly what time and what type of medications were given to me. He's only assuming from some records that he may or may not have been involved with. He doesn't know what the volume of the doses were or what types of medications could have had. He didn't testify to what kind of impact those combinations of medicines could have had. He did not speak with law enforcement, and his responses were quite vague. Then to the other medical professionals that testified. Teresa Wagner, Rita Hall, and Francesca O'Neill. They were all involved in some kind of DNA analysis or some kind of evaluation of Mrs. Mathewson's injuries and the sexual battery kit. And again, that sexual battery kit, the test came back, no evidence of rape pointing to me. No DNA match to me. And this happened immediately after the alleged sexual encounters. This didn't happen after Ms. Mathewson showered. Her allegation is that this happened on Sunday, and this test happened, and the rape test was given to her on Monday. They also tested the clothing from Mrs. Mathewson, and none of that tested positive for myself being in contact sexually with Ms. Mathewson. The sheet from the bed tested positive for my DNA, which the analyst said could have been there that day or sometime prior to that. As you do know from Ms. Mathewson's testimony, we were in contact prior to the 11th of March. I also ask you to consider the testimonies given by law enforcement. They were not a witness to anything prior to a simple, peaceful arrest. I did not resist. I did not see, not have any testimony of me causing any problems or acting in any kind of irrational way with them when I was arrested. They did not attempt to investigate, despite all of this available DNA, fingerprint analysis, things that could have corroborated the story, maybe made it a lot more sense for you. But they did not attempt to test the pillows to say, yes, this is evidence of her accusation. They did not attempt to test the Christmas lights to see if there's any trace, as the fingerprint expert testified to see if there's anything on the glass bulbs or any kind of skin, any kind of anything with these Christmas lights. They did not attempt to test all of those items in the vehicle. I asked Mr. Becker, could this have been tested? Could this have been tested? And it was their position that, yes, it could have been tested. And if you think about it, think about all the things. When you look through those pictures, look at all the things that were in those vehicles and line them up with Mrs. Mathewson's testimony and see, would those things have some value? I believe you would find that to be true. I also believe that the contents in the trash can, the rope, they collected it, but it was not tested to see if there were any kind of skin or DNA evidence on that rope. That probably would have been a good thing to do. They did not check the NyQuil bottle, the other bottles, the broken wine glass. Look at all these things. They did not check to see if any of those produced any kind of evidence that would corroborate the allegations against me. So you have to ask yourself, is that reasonable? Is that fair? They also did not check anything about this statement that they collected from me in a hospital that was taken after, again, you know that high dosage of medication was given to me. They did not check to see if there were boat charters on any kind of schedule or any kind of thing that could have even corroborated my story there. They did not check to see if I had offshore accounts. They did not check to see if any of these directions that I'm giving. If you listen to that interview, I'm talking about this road and that road. I don't know. Maybe you guys are familiar with the area. Maybe you know.
Objection, Judge.
I will instruct Mr. Trevor not to place the jury in your shoes or the shoes of any party. Don't make arguments like that where you to the jury.
Okay.
You can argue and you can argue the facts, but avoid what you just did.
Gentlemen, I would just assert that the law enforcement did not check to see if these directions even fit to a map. And they also didn't seem to think that the statement about immigrants was a little bit out of whack. I encourage you to listen to that video or that audio of this interview and see if someone really does sound like they make sense, or if they sound like something different, in fear, in panic, concerned. Look at the condition that I'm in, look at the medication given, and please draw a conclusion from that. I also submit to you that law enforcement failed to recognize any red flags or false statements regarding if I owned a house and if I was able to just sign it over to somebody. If I owned a car, if I'm just able to sign it over to somebody. Or even if the passwords to the bank accounts were valid or not. These all would have been important for you to make a decision about whether or not I was giving correct information. The police also purposely did not interview me when I was awake, sober, clear-headed, or recovered. They only interviewed me one time at a hospital where I was vulnerable. That's it. There's no other time. They didn't come and ask me later if I could please explain things better to them. They didn't come with a written statement, ask me to sign it. They didn't try to attempt to get any other information from me. They thought, case closed, he said what he said, and that's it. I also submit to you that law enforcement made no attempt to follow up on the marks on either side of Mrs. Mathewson's neck. Again, they took some basic statements and said, it's been a long weekend, we're just going to conclude here. Law enforcement also could have taken more items into evidence to fill the holes in the story and to corroborate this story. And I believe that would have been much more helpful for you to make a decision in this matter. Then we turn to the children. They only said a few things. I didn't ask them much. I didn't believe they even said too much of value, but the little bit that they did say, it contradicted their mother being dragged down a hall in the house. It contradicted what their mother said about being restrained in the corner of the living room. It also shows that mother had no interest in speaking to them when the oldest, Arden, came into the home, while the youngest two were into there. There was no information given to them. There was no concern to them about while Mrs. Matthews and I are arguing and fighting in the home. And then we turn to the statements of Mrs. Mathewson. These statements were outrageous. The statements were exaggerated. The statements were, most of them, impossible. The responses to simple questions were abrupt and over the top. The calm answers, if you recall, they revealed some truths, such as wrestling in the living room. That's a true statement. Such as sleeping in the car. That's true. Such as not caring about sex. That's true too. Such as just calling it sex. That's true. About being woken up by water droplets rather than some other crazy way. If you guys remember the timeline that was presented, they say that I came to her house at 12:30 in the morning, and she finally woke up around 3. Text message showed between me and my children, and I'm trying to wake her up. Showed that I tried to turn on the television loud, I tried to put lights on and off, I tried to slam some doors. I think you guys can understand that. I also ask you to pay attention to the statements that Ms. Mathewson made. She drove to my neighborhood after these prior allegations. She said nothing to our children to help her in this alleged situation. She was already in the bedroom, and she made no statement of being drugged back into there. She claims an entire bundle of rope fit in my jeans pocket. That rope, again, was not tested to see if used in any allegations here. She claims that there was a sock in her mouth, but does not recall those details. And as you go through the evidence, you'll see that no sock was recovered. You'll see that no sock was tested to corroborate this claim. She claims that duct tape was on the mouth, but again, nothing corroborates this. You have a picture of duct tape. You have a very simple thing that law enforcement could have tested and said, yeah, what she said is true. Press start here. You also have a statement about predominantly calling it sex, and then has a cigarette after each time. She offers no details like in the other accusations. We just had sex, and we move on. She also says that she was screaming when she came back to the vehicle at Walgreens. Again, no witness made this kind of observation. She says that she opened her car door with her back to it and did not tumble out on the ground. She says that she refuses to recall the majority of the time we were together over the weekend. If you recall, we were together roughly 30 hours parked in the country, in the woods. But she can't remember most of the conversations that we had. She also says that we are driving around on Monday morning between the hours of 6 a.m. and 10 a.m. on some very busy roads. But she made no effort to signal another car or really elaborate on any of that time for you. She also states that we argued throughout the weekend, and that should truly help you understanding the range of emotions that were happening, the things that were happening in a divorce situation.
Objection, Judge. Facts not in evidence.
Again, I'll instruct the jury to rely on their own recollection of the facts were. I'll caution Mr. Summers to please avoid arguing or referring to any facts that were not testified to in this case.
Yes, sir. Then we'll go to my interview. If you evaluate me on this statement made in the hospital, I'd hope you'd find that it doesn't make much sense. I hope you find that there are a glaring number of issues, sometimes in, sometimes out. Things about, again, bolts and incongruent driving directions, about immigrants, about a variety of things that really show a concern for the situation I'm in. So please evaluate that based on the conditions that you know surround that interview. Aside from this, gentlemen, I just remind you that from the beginning I've assumed my presumption of innocence, and I maintain this until now. I assert that the state has not proven what was in my heart, especially regarding 2 counts of
Objection, Judge. Inappropriate requirement of the state to prove what's in his heart.
I'll instruct the jury that what Mr. Summers say is certainly not the law. In this case, the law will come from me, and the elements of the crimes will be contained in that law. Mr. Summers, restrict your argument to the law and the evidence in this case, please.
Yes, sir. I'll rephrase that, gentlemen. The state has not proved my intentions. They have not proved that I intended in counts 1 and 2 to kill Mrs. Matheson. In my statement in the hospital interview, I clearly never said I intended to hurt her. If you're relying on that, that's fine. I never said I intended to kill her with a pillow, and I never said anything about the rope. Never mentioned the incident one bit. I'm also going to assert that they did not show any intent to steal a car. They did not show that that was the underlying reason that Mrs. Matheson went with me. They did not show that I intended to kidnap her. There's a lot of holes in their story, and I ask you to please consider that when evaluating whether or not you find the the facts true. They also did not show my intent to take advantage of Ms. Mathewson in any sexual way. You've heard the way I've described it in my interview. You've heard the way she's described it, and I hope you can appreciate that. I also believe that you would find that they did not prove that I intended to steal a car, which is one of the later charges on this long list that they've put together. I believe you would find that it is a civil matter, and that when two people are married, they commonly use each other's vehicles, even if they are separate.
Objection, Judge. Improper argument.
Again, I'll instruct Mr. Summers to limit your argument to the facts and the law that are applicable to this case.
Gentlemen, I assert that utilizing cars while married is a civil matter. I also don't argue other issues. I ask you to just be favorable in understanding my position here. I ask you to please be cautious in understanding what burden of proof the state has to provide and how high that threshold is, that you cannot have doubts about these allegations. They are very serious.
Objection, Judge. Misstatement of the law.
I will instruct the jury that, again, what Mr. Summers says is not the law. You will hear the definition of reasonable doubt when I instruct you on that law.
And so, gentlemen, reasonable doubt, I believe, is everywhere. And I ask you to please remember that and to please focus on that element that has to be proven by the time that you make these decisions about my life, about the situation that you've been presented, about deciding whether or not to find me innocent or guilty. I ask you to please consider all of these factors and see that what I am trying to show you is that this was a very abnormal series of events, and it requires a lot more information for you to draw a conclusion that would say that I absolutely am guilty of these crimes. And so for all of these reasons, gentlemen, I thank you for your time. I thank you for giving me the opportunity to explain this to you and to share with you a better understanding of putting it together. I thank you for allowing me to paint a little bit better of a picture, and I do appreciate your time, and I value your opinion on this. And I do ask you to please find me innocent of the charges against me, and to consider what else may be available to you as you are instructed by the judge. Thank you. Thank you, gentlemen.
Ms. Johnson, rebuttal from the state.
May it please the court, Mr. Summers, co-counsel, members of the jury.
Okay, Art and Landon, I need to give you guys some information, and I want you to make sure you understand this. I spent a lot of time with Mom the last few hours, and the the things that she's told you about me being good at manipulation, control, and lying is true. And tying her up.
That is Trevor Summers in a nutshell. Manipulative, lying, controlling. And Elisa Mathewson finally had the opportunity to stand up to him on that witness stand this week. She finally got the opportunity to stand up for herself and tell you exactly what happened on March 11th, March 12th, and March 13th. The defendant chose to represent himself, and that you have a special instruction in which to consider that. You are not to base your decision because you feel sorry for him, because you dislike him, or because you like him. You are to base your decision upon the law and the facts and evidence that have been introduced during this trial. The same goes for any witness that took the witness stand and the attorneys in this case. You must not make any decision in this case because you like or dislike anyone. It must be based solely upon the evidence and the law and the facts in this case. I'm going to touch upon some arguments made by the defendant a few moments ago. He said that there were no dents, no glass broken, no blood at the home. Did Miss Mathewson ever describe the incident of her being pulled from the bed by her feet and taken into the family room? Did she ever describe it in a manner that you would expect to find broken glass, blood, dents in the walls? No. She described it that he pulled her from the bed from her feet. She was throwing items at him, and then he guided her out into the family room, and she kept trying to get up and try to run out that door. That's what she told you. So I would submit to you that the photographs that were taken on March 12th of 2017 of her home clearly depict what had occurred. They corroborate what she told you had occurred in that family room. We see the pillows nicely aligned on the sofa that she was laying on earlier that night watching the Storks movie with Bryn and Grady. The pillows are put on the couch in a neatly fashion. Look at the photograph of the way the pillows are on the couch that she tells you that she kept trying to run from the defendant on. They're all on the ground. He says, look at the fact that the cup and the Kleenex aren't where they were. She said she threw them. What do we know about what happened in that room? We know Bryn and Grady were in that room after they were told to go back in the room, after the defendant told them to go back in that room and not come out. We know they were in there for some time, worried about their mom, yelling to their mom, "Are you okay, Mom?" And she yells back, "Everything's fine." Could they have picked up the cup and put it on the countertop, picked up the Kleenex box? We know that Miss Mathewson and the defendant were in that room for hours on the 11th. Is it unreasonable to think at some point when he walked in the room to tie her up multiple times, he picked it up, picked the Kleenex box up? No. He said that she was not tied when he went to Walgreens. Why would he take his estranged wife to go see the children for one last time tied up? The problem with him making that argument is that in his recorded post-Miranda interview, he says that he tied her up. So he's arguing moments ago that he didn't tie her up to go to Walgreens, yet in his post-Miranda admission, he told the law enforcement officers he tied her up. He said, I said, should I at least tie your hand so you don't do anything dumb in the car? He tied her up. about the blisters, the blisters that, why would she go walking in this area, or this area was high brush, high dense area, and that's how she got those blisters. And then he was like, well, why didn't you wear flip-flops if you already had the blisters from being tied up? And she explained, he said they were out in the woods. She described this as a high, densely brush area. And she was not going to wear flip-flops to walk through this, on this journey that he was going to make her go on to go find water. Is that unreasonable? He says in the video that he made that he was being nice and asking her what else he should include in that video. You don't see her in that video. She's not a happy woman who just had sex with the love of her life, wrapping her arms around his shoulders on that video. She's hogtied, laying down. That's why you don't see her in that video. He talks about the Walgreens video. He wants you to go back and watch that video. I'd recommend that you go back and watch it. Because what you're going to see is you see him walking into the store. He goes out of camera for a minute. He comes back in the angle of the camera looking out into the parking lot. And soon thereafter he realizes that Miss Mathewson had managed to escape from the car while tied up. And he walks out of the store, and if you keep watching the video, he then proceeds to start running after her. And Mr. Crosby testified that he saw the defendant come from the store running to Miss Mathewson. Grabs her. That's how Mr. Crosby describes the interaction. Grabs her and takes her back to the car. After she was yelling, "Please help, call the police." If that's not kidnapping, what is? Why would he park in front of the store if he had tied her up and she was going with him unwillingly? You heard Miss Mathewson explain over and over again. She was with him for 16 years. She placated for him. She did what she had to do, so there was not conflict. She did what she had to do on March 11th, 12th, and 13th to stay alive. She was staying on his good side. She was going to do what she needed to do to make sure she stayed alive. That's exactly what she was doing this entire time. And it was finally on the witness stand this week that she was not going to placate him anymore. She was not going to go along with what he said. And she stood up for herself. The McDonald's video is a classic example of what their marriage was for 16 years. Of her going along with what he said. He had threatened her before they went through the drive-thru, if you do anything, I'm going to hurt you. So what did she do? She did what she had done the last 16 years and just went along. She knew she had to do that to stay alive. He argues to you, if she could have gotten out of the car, I wouldn't have been able to get out of the car. My door would have hit the building. He was in the car. He could have run her over with the car. He had already tried to suffocate her one time. What would stop him from stepping on that pedal and running right into her if she tried to flee? She tried to flee one time. Remember, she tried to flee on March 11th at the Walgreens. She tried, and she was unsuccessful. So she knew from that point on, she had to just go along with what he said until there was another opportunity or until she was going to be able to convince him to let her go. Watch the Sitco video again. What did she tell you about what happened when they were at the Sitco? She was required to go back to the third row because he knew that the last time he left her in the vehicle, she had tried to run away. So she had to go into the third row and watch the video. Watch his demeanor and his actions in that video. He couldn't grab that dip fast enough from the employer or the employee there at the Sitco. He didn't wait for his change. He goes to proceed to walk out, and then he remembers he wants to get a newspaper. Because why? He probably wants to find out if people are writing about what had happened. The kidnapping of Miss Mathewson. Because he had been listening and looking for it on the radio. So he gets the newspaper again. He doesn't even want to hand the newspaper over for the Sitco employee to scan it. The employee almost has to grab it from him to be able to scan it. He throws his money down again, and he leaves. And the entire time that he is standing at the countertop, he is looking out the window for Miss Mathewson. Going back for a moment to Mr. Crosby, he says that he didn't know the make and model of the vehicle. He was more concerned about the license plate. Well, what's more important to give to law enforcement? Is it more important to get the make and the model of the vehicle or the license plate? And he is the most independent, non-biased witness in this case. And recall his testimony. He saw her with her hands tied behind, behind her back, running, yelling for help, call the police. And then the defendant, who he can identify, grabbed the victim and put her in the car. He talks about Kimberly Shea and that she described during cross-examination that she thought possibly maybe her hand was resting up on the door and that she looked distressed. And Miss Shea, 5.5 years later, the first time she's saying about the hand on the window was through the Zoom testimony, 5.5 years later. She told you she gave a very detailed written statement that included descriptions of both the male and the female, what she observed, the car. But that one statement of hers was not in that written statement. But he wants you to hold on to that so tight. But what we already know from his statement and Miss Matthews's statement and Mr. Crosby's statement is her hands were tied. Because in the interview with Sergeant Remia, he admits that he tied her hands up so she wouldn't do anything dumb. Why would he have to tie her hands up if she had agreed to go with him? Let's talk about his interview for a minute because he keeps harping on the fact of the medication that he was provided, that Hillsborough County Sheriff's Office didn't follow proper procedure in interviewing an individual in the hospital, that his statement was not knowing and voluntarily made. The state would submit to you that that 37-minute recording speaks for itself. He was provided fentanyl at 12:18. What did Dr. Chesla tell us about fentanyl? It is fast on and fast off. It quickly relieves people of pain, and it quickly wears off. We know that there were other drugs prescribed because they generally give nurses options for different pain management. But he told you that looking at the list, none of them had been given other than the fentanyl. None of the other drugs have been given to him. And listen to his recording again. He is clear. He makes sense. He does the majority of the talking. He says, this is just the cliff notes. I can provide more details if you want them. Those are his statements. He's not saying, I can't talk right now. I'm in so much pain. I don't understand the questions you are asking me. Can you come back? None of those things come out of his mouth. He could not been clear on the facts and circumstances surrounding what occurred those last 2.5 days. The DNA. There was no DNA linked to the sex battery kit of Miss Mathewson, of the defendant's DNA. Well, we know from the defendant's own statement that they had sex. The issue for you to resolve was it consensual or not? So the fact that there's no DNA there, he didn't argue to you that they didn't have sex. What does that matter? The issue with regards to the sex is whether or not it was consensual. And the state would submit to you someone who sneaks in Miss Mathewson's home in the middle of the night, ties her up, the sex was not consensual. It is not reasonable to believe that someone would consensually have sex with that man after he tied her up with scarves, rope, Christmas tree lights. And that's not all just coming from Miss Mathewson. It's his own statement. He tied her up with the Christmas tree lights. So what would the DNA results on the Christmas tree lights give you? He already tells you that he had tied her up with the Christmas tree lights. What else did we learn from the DNA from Miss Montgomery O'Neill? That if people shower, that's going to affect the DNA. If people go to the bathroom, that's going to affect the DNA. And if someone has a vasectomy, that could affect the threshold. But again, the state doesn't have to put the semen inside Miss Mathewson. He admitted in his own statement that they had sex. The issue is consent. He talks about that law enforcement did not follow up on the writings, that whether a house can be transferred via writing, that a car or bank accounts were the correct bank account numbers. The thing with that, ladies and gentlemen, the state would submit to you that he never intended for Miss Mathewson to have any of that stuff. If you look at the note to the children, that explains 100% what his intentions were. His intentions were to kill Miss Mathewson and himself. You decide what kind of letter that was. Miss Mathewson was never going to kill herself. All she wanted to do was get out of the situation alive and to be with her children. He never intended for her to ever get out of that car. So he's going to pretend like, I'm going to let you go as long as you don't call the police. And she's like, I promise you I will not call the police if you leave me these things. But he was never going to let any of that happen. So he didn't care if it was a valid quitclaim deed or a valid surrender of his parental rights, because he knew all along what he was going to do. He knew all along that he was going to kill her. And he was going to kill himself because he was going to be watching his children from heaven. That was his plan all along. He wrote those letters when they had arrived on the Anna Maria Island. They had pulled off. This is coming from Miss Mathewson and his own statement. That's when he wrote the letters. That's when he wrote the confession letter. That's when he wrote the letter of the surrender of the parental rights. That's when he wrote all of these letters including the letter to the children. But Miss Mathewson never knew that letter to the children was written. She never saw that letter. He was never going to let her know he wrote that letter, because she would then know what the plan was. So he's driving around looking for this flag. That's what he told her. He was driving around trying to get up the courage to do what he knew he was going to do all along. He was trying to find the right place, but he didn't find the right place at Anna Marie Island. So then he moves along to Little Harbor. And that's when he had enough courage, he was going to handle it. He was going to kill her then. That's when he got in the third row, and he took the rope around her neck and began to strangle her. And then he jumped in the car and fled because he saw an undercover vehicle. So these writings and the fact that law enforcement didn't follow up on them mean nothing. Because to him, those writings meant nothing. He was never going to let her out of that car alive. He brought up Bryn and that her testimony contradicted Miss Mathewson's testimony. She was 7 years old when this happened. 7. What did she tell you, though? She told you that she saw scars on her dad. She told you that she was in fear for her mom. She was afraid for her. Is that contradictory of what Miss Mathewson told you? The defendant brought up the February 18 incident, and the judge read you a special instruction as to how you are to consider that evidence. And the state would submit to you that you must follow that instruction. And one of the ways that you can evaluate and consider that is to corroborate the victim. He talks about how Miss Mathewson can't remember conversations that they had for the 30 hours that they were in that car. What did she tell you? She told you that he can just talk and talk and talk about nonsense ad nauseum. Nonsense. And he tries to act like that there was this big tumultuous arguing happening over these 30 hours. That's not what Miss Mathewson told you. She was playing along this entire time with him. There was no arguing. There was no tumultuous situation happening. There was no wrestling in the car. Look at the photographs in the car. Are there things strewn about that it would show that there was some kind of wrestling that he wanted to try to say that was happening in the car? And that's why she got those marks on her neck. Because he doesn't want anybody to think that it could have been from him possibly strangling her. The nonsense. His statement, he says about the immigrants and that these boats, about these different times he was going to get these boats. Miss Mathewson was clear. Based upon things in their marriage over 16 years, there were reasons for her to believe what he was telling her. Miss Mathewson's vehicle was not a community vehicle. She left him. She moved into that home herself. She bought herself that car, and she had a job. That was not his car. That was her car. His car was the minivan that he decided to send his 14-year-old daughter in to drive the 12-year-old and 5-year-old and 7-year-old home. That was his vehicle. She didn't even know what kind of vehicle he had just gotten. There were no marital vehicles at this time. He had his vehicle and she had her vehicle. And she didn't give him permission at any time that weekend to take her car. Everyone reacts to a traumatic event differently. There is no one formula or way that someone should react to a traumatic event right after the incident or 5.5 years later. This is not a situation where Miss Mathewson was kidnapped by a stranger. This was someone who she had been with since she was a teenager. For 16 years she had been with him. So she knew what she needed to do to try to stay alive in that situation. And that's why she acted the way she did. Why she acted to try and befriend him, to keep him calm, to try to not have conflict, because she knew after 16 years that was the only way, the only chance she was going to ever have to possibly get out of this situation alive. The topic of a Baker Act was brought up during the testimony of the trial, but it's clear from the evidence and Sergeant Steele's testimony is that the defendant was never Baker Acted. He was booked in at the jail on the 14th. There was no 72-hour hold on him. He was in the jail the next day. Another thing to consider when he wants you to think that he is not of the right frame of mind when he is making his confession. But you don't have to just rely upon that confession. We have the written confession from him, and we have the videotaped confessions from him. He wasn't on fentanyl then. He wasn't suffering from his self-inflicted wound then. You have multiple admissions from the defendant. I want to take you through a few inconsistencies in his statements. He had told originally the victim that he had, Miss Mathewson, that he and law enforcement was the purpose of going in there was to say goodbye. He was going to say goodbye. In the middle of the night, he needed to sneak into her home to say goodbye. But then he tells his 14-year-old and 12-year-old that the reason he needs their help to get into the home is to address legal issues, and that he was going to convince Miss Mathewson to come home so they could be a family again. Let's talk about the wrist cutting situation, because Miss Mathewson was clear in her testimony that he cut her wrist because he was mad that she had tried to flee from the Walgreens. And it was done intentionally and purposefully. In his recorded statement, he tells law enforcement that he cut her wrist accidentally when he was cutting the rope. Well, let's look at the evidence in the case. We have the back of Miss Mathewson's shirt. The way she wears that is you put your arms through it, it buttons down the front, and where all the blood is in the back. So what does that tell us? What it tells us is that her hands were tied behind her back. She was cut because he was mad that she had tried to flee at the Walgreens. And she bled all over the back of her shirt when her hands were still tied together. He never cut her when he cut the ropes off, because if he cut her when he cut the ropes off, the blood would be on the front of her. The blood would be on the front of her clothes. Miss Mathewson knew she would be hurt if she tried to fight again or if she tried to flee again. So she went along with him in order to make sure she didn't get injured. And that's exactly what she told you. The evidence in this case corroborates every witness and every detail Miss Mathewson has told you. He tells you in his recorded statement that he's dead tired, so he had to stop he had to park and drive in those woods. He was dead tired. If he was dead tired, how can you believe his statement that the two of them slept for hours earlier at her home? They slept for hours together. How did they sleep for hours after they had this consensual sex? And then he be dead tired. He was dead tired because he was up for over 24 hours. There was no sleeping after this consensual sex. He was dead tired of having to tie her up multiple times and keep watch on her, trying to get into her phone, find out who she had been talking to. That's what he was dead tired from. If you listen to his recorded statement, he almost makes a slip up and talks about this letter that he discusses that he and Miss Mathewson are going to watch the children from heaven. When he starts talking to the Sergeant Remia about the letters that he wrote, he says, drove all the way into Anna Maria. Right before Anna Maria, there's a boat ramp. We parked, sunlight starting to come up, and she wanted me to write some things. And she said if I did that, she wouldn't tell the police anything. So I wrote out, that she can have the house, car, the money, and whatever I left. Just said and then she wanted me to write, no, she didn't want me to write that. He almost said that he wrote the letter to the kids when he was talking to law enforcement, but he knew he couldn't admit to that because his whole floating over, not discussing the strangulation in that post-Miranda interview would be shot out of the water. He almost confessed to that, but he caught himself because he knew some of his story wouldn't make any sense anymore. He thought he was going to be able to get away with explaining the suffocation of the pillow as a pure accident, a joke. He was just being an ass. But he doesn't even mention the strangulation. He doesn't mention the strangulation because he knew he wasn't going to be able to cover that up once they had found that letter to the children. So he purposefully leaves that out of his statement. It's not a defense. The fact that your estranged wife joins a dating app, that's not a defense to any of these crimes. The fact that she's dating a man that she's now married to, not a defense to the crimes. The fact that she agreed to go with him at one point and changed her mind, not a defense to the crimes. The fact that she has sex with him and is dating other people, not a defense to these crimes. The fact that he wasn't right in the head, needed to go away, not a defense to these crimes. This isn't an insanity case. None of the reasons he gave Sergeant Remia in his confession are defenses to any of these crimes. The state has the burden to prove this case to you beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. What does abiding conviction mean? Abiding meaning firm, conviction meaning belief. If you have a firm belief that the defendant committed these crimes, you must find him guilty of those crimes. He had made the decision that if he couldn't have her, no one would, or no one could. And all of the evidence in this case corroborates each and every single witness that the state has put forth to you. I briefly want to touch upon the aggravation with regards to a weapon when it comes to counts 1 and 2. Because the state has charged him with attempted first-degree murder with a weapon. The weapon in count 1 is the pillow. The weapon in count 2 is the rope. The definition for a weapon is 1, any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that was used, threatened to be used, attempted to be used, or intended to be used to inflict bodily harm. He took that pillow and put it over Miss Matthewson's face, pushed down with all of his weight until she wasn't struggling anymore. He used that pillow in a manner that could be used to inflict bodily harm. Therefore, it was a weapon. The rope. He took it around her neck from behind. The only reason he wasn't successful was because she had her hands tied this way and was able to catch the rope, prevent it from going around the front part of her neck. That rope was used in a way that could have inflicted bodily harm. The state would submit to you, we have proven that the pillow and the rope are considered and are weapons on the March 11th date and on the March 13th date. The facts in this case are almost unbelievable. But with the mountain of evidence that the state has proven to you, has given to you for you to look at and review, tells you exactly what happened and tells you that the facts are not unbelievable. That they are as stated. They are fact, the state would submit to you. The mountain of evidence, the overwhelming evidence in this case points directly to the guilt of Trevor Summers. And we're confident that at the conclusion of this case, you will find him guilty as to each and every count. Thank you.
Gentlemen of the jury, we're going to take a short break. I'm going to give my court reporter at least a little break before I read the instructions to you. It'll also be an opportunity for you to stretch your legs, use the restroom if necessary. It will be a short break. We'll come in and I will read you the final instructions, and then you will return to the jury room to deliberate. Please do not discuss the case amongst yourselves or with anyone else. Please do not do any research related to the case. All rise for the jury.